Uh, my name is Jonathan Rosenberg. I'm the president-elect of the San Diego chapter of ACC. And today we are having a presentation from Paul Plevin Quarles on pricing disputes in inflationary economy. We have Brandon Krajewski from the Milwaukee office, Christina Snyder from the San Diego office, and Jackie Westling from the Phoenix office. So thank you very much for everyone joining today and looking forward to the presentation. I'll go and hand it over to you.
Great. Welcome, everyone. Thank you for joining us for our presentation, Pricing Disputes in an Inflationary Economy. As Jonathan mentioned, I'm Christina Snyder. I'm an attorney in the San Diego office of Paul Plevin Quarles. And some of you may know that the name Paul Plevin Quarles reflects last year's merger, which was between Paul Plevin, Sullivan & Connaughton, LLP, a top management side employment law firm in California, and Quarles & Brady, which is a full-service law firm headquartered in Milwaukee with 13 offices across the country. Here's our 13 offices, just flash that on the screen. I handle both business litigation and employment issues out of the San Diego office. And I'm joined by my colleagues, Jackie Westling from our Phoenix office, who's licensed in California, and Brandon Krajewski, from our Milwaukee office, who enjoys supply chain disputes so much that he authors a series of articles on our website entitled Supply Chain Survival. So he's a litigator and also can handle some drafting issues as well. So I'll let Jackie and Brandon introduce themselves a bit more at this point. Jackie.
Sure. As Christina said, my name's Jackie Westling. I'm a partner in our business law group in the Phoenix office. My practice focuses primarily on venture capital as well as outside business services for our clients that aren't quite large enough to have their own legal department, but still need counsel on a fairly regular basis. So as part of that, I spend an awful lot of time, and I enjoy doing it, working with our clients on their commercial contracts, including their supply agreements.
And Brandon?
Hi, good afternoon, everybody. Brandon Krajewski out of the Milwaukee office. I'm a partner in our commercial litigation group. I am the co-chair of our government and commercial contracts dispute subgroup. And as Christina said earlier, co-author on our Supply Chain Survival Guide series. My practice, it'll shock you all, is primarily related to supply chain and manufacturing disputes and handling litigation, pretty much a 50-state practice all around the country for both buy-side and sell-side disputes. And then I work hand in glove with our business law groups and other departments to make sure that the lessons we learn on the litigation side make it back into the drafting and best practices for the rest of the firm. So very happy to be talking to everybody today.
Great. And I'm very excited to have Jackie and Brandon here today because they have such a wonderful wealth of combination of experience with both drafting the contracts and litigating the disputes. So today we will first start talking about some steps that you can take up front at the beginning of a relationship to avoid pricing disputes down the road. And Jackie will handle that part about how to draft a contract and things that you could think about while you're drafting them. And then Brandon will discuss the methods of managing and resolving disputes that do arise and some practical solutions once a dispute is underway. We will wrap up with some questions and answers if we have time. If we don't have time to get to all of your questions, please just email us with questions after the program. So, as you know, the title of our presentation is Avoiding Disputes in an Inflationary Economy, but why are we talking only about inflationary environments? And the short answer is that we are not. These disputes come up anytime the economy takes an unexpected turn, and it feels like the economy has been taking unexpected turns for the last few years. Maybe at this point, we have this sort of steady unsteadiness, but we still don't know what's around the corner. So inflationary environments tend to increase the number of pricing disputes because when the economy is steady, you're not getting calls from suppliers demanding price hikes, and you're not losing money in your customer sales. But when inflation starts picking up, that which was a good price previously suddenly isn't any longer. There's a general unease right now. And interest rates and inflation remain steadily high. We know that some industries are still under pressure, but the pressure varies among the industries. So basically, these kinds of disputes can arise anytime. We're just seeing more of them now. And so putting up some guardrails while you're drafting and thinking down the road while you're drafting the contracts will help alleviate disputes in the future. Jackie and Brandon, did you have additional thoughts on our current climate and the kind of disputes that you're seeing right now? Jackie?
Yeah, I think not so much on the disputes because I try very hard to avoid the disputes and having to talk to Brandon. But I think maybe kind of the lasting consequence that we're seeing from the volatility is that now, even as things are somewhat more stable, more and more of my clients are insisting that they have some kind of worst case scenario escape valve. And in fact, I had recently a client tell me that he will almost always, if he can at all make it work, make sure he has a termination clause, a right to terminate, even if that comes with a penalty or a premium of some type, but just to give him the flexibility to deal with the unknown. So that's something that's impacting my practice, notwithstanding kind of some of the subsiding pressure.
Yeah, dovetailing on that, I'll say, expected inflation is easy to deal with. Unexpected changes in inflation are what we see cause a lot of problems. And so we've seen a lot more, as you said, the zigging and zagging of the economy. I think we've got a little bit more geopolitical risk right now in this moment than we have since sort of the beginning of COVID. And so people are a little bit more wary on contract duration issues, things like that. I think you'll get into in a bit. I think as far as the type of disputes we're seeing, I'll get into it in a little bit more detail later. A lot of tail end COVID cases, they're getting towards the statute of limitations in some states, depending on when some of the events occurred. So seeing some issues that couldn't be managed through commercial negotiations coming into the litigation forum quite a bit in that sense right now.
All right. So now we're going to turn I'm going to turn the mic over to Jackie to talk about the drafting side and some things to think through when you are drafting contracts.
Yeah, thank you, Christine. As you mentioned, I think we want to spend just a little bit of time, not a lot. Most of the folks here probably know their way around these contracts very well, but just a few kind of practical pointers to try to mitigate the chance that there is a dispute. And then I'll turn it over to the two of you to talk about what happens when and if that does occur. And so the first thing we're going to talk about is those transactions where the parties are doing business through purchase orders, quotations, RFPs, confirmations, the like, as opposed to the signed bilateral agreement. And a few points there. First, be very specific in the pricing provisions. I know that seems obvious to us, but it may not be to your sales team. So if there's any assumptions that went into setting the price, make sure those are spelled out in the purchase order or the confirmation or the quote. Secondly, if you do have a price adjustment mechanism, you need to make sure that's included there as well. You usually see that more in the bilateral supply agreements that are signed by the parties, but as we all know, these are binding contracts, although we may not know what the terms of the contract are, but we'll get to that point later. So be very specific. And then finally, something that's become even more important is making sure the sales team knows to put a deadline for acceptance into a purchase order or a quote, especially a quote. Give the customer a short time frame, a week or two, to respond, and make it clear that if it goes past that time frame, you're going to need to requote the price. And part of that is because, if we've learned anything over the last 10 years, it's that things can change very quickly in today's economy. Whether it's from a pandemic or a boat stuck in the Suez Canal, things can change on a dime. So even more important to make sure that your quotes reference a deadline for acceptance. The next slide, there we are.
Hey, Jackie, before you move on there, one other thing, just quick on quotes, something I've seen a couple of times, make sure if you're issuing quotes if they have enough detail to be accepted, that you have all the details in there that you'd want, should it be accepted as a contract. Sometimes you see a little bit more informal quotes go out that have, price, term, quantity, et cetera. That's an offer. And if it could be accepted, you want to make sure you've got all your sort of defensive terms in there that you'd want with any contract. Alternatively, you want to have something in there that clearly says this is not an offer or can't be accepted and subject to further negotiation, et cetera. I've had 2 disputes that I can think of off the top of my head that were, a really bare bones quote that was functionally accepted when the other side sent in an invoice, and the dispute down the road is all over, what terms and conditions controlled, and it was because they just weren't formal enough. So
Yeah, and that goes to the point where, the in-house legal department knows all this, but out on the field, the sales team may not know that. And if there are specific assumptions, for example, if you agreed on a price based on a purchase of a minimum requirements or a minimum number, they need to spell that out in the quote. If you're purchasing and you're agreeing to a price because you're expecting that price to be a fixed price for a period of time, that needs to get into those documents. Because as you say, they're contracts, even if they may not look like it to the sales team. So moving on, probably really the best way to avoid a dispute is, at least in my opinion, and we can talk about that a little bit more. I know that some of us have some war stories on that, but the best thing to do is to actually have a written supply agreement. Not always possible. Sometimes you're just going to have to do business on the POs and quotes. But if you can have a written agreement signed by both parties, you're in much better shape. And the reason for that's really twofold. One, you know exactly what you're agreeing to. You have the ability to be specific. You have the ability to spell out conditions on the pricing, requirements on the pricing. If there is an adjustment mechanism, you can spell that out. If there's a time frame on the adjustments or conditions to the adjustment, you can spell it all out. That doesn't mean you're not going to have a dispute. And even the best drafted contracts, Brandon and Christina can drive a Mack truck through. So you always have the risk that there will be a dispute, but you're much better off if you've got a written agreement. And then the second reason, and this is the one I think is most compelling, is you avoid the whole battle of the forms dilemma. And most of us know what that is, even if we don't have to deal with it on a regular basis. And if you're like me, it makes my head spin every time I look at it. Brandon, I know you're the expert and you think you know what the result will be, but every time I have looked at it, I've come back with my hands up in the air that I don't know what's going to happen. And certainly it will come as a surprise to your sales folks. They have probably little idea about the pitfalls of the battle of the forms. And basically what that is, to state the obvious, is one party puts out their document, whether it's a request for a quote, a purchase order, a quotation, and they carefully attach all their very well drafted terms and conditions, or they reference them on their website. The other party accepts the quote or accepts the purchase order, and they attach all their well drafted terms and conditions, and the two don't match. And when that happens, at least in my experience, you never know exactly what the outcome will be. You can default to UCC provisions, but they will vary from state to state. So if you're doing business in a multiplicity of states, you probably have a multiplicity of problems. But I think the takeaway for me on this one is that one of your best defenses is to make sure your team is kind of trained up and to make sure that they understand the process, they understand the pitfalls, and whatever best practices the legal department has come up with to engage in the battle of the forms, make sure they're aware of those and how they're used. And I'm seeing that a lot now from our clients where they want materials to do training programs. Certainly something that we can do, but it goes a long way to not having that unexpected nightmare of dueling documents. You're still going to have it, but it helps. Interestingly enough, Brandon told us when we were preparing for this, and I wish I had known this earlier, that he had co-authored an article on the Battle of the Forums. So Brandon, maybe you could share a little about that, and also maybe talk about whether, I'm wrong. And when there are the situations where it does make sense to go the Battle of the Forums, the transaction documents, rather than the supply agreement.
Yeah, we do have a Battle of the Forums article as part of our supply chain survival series. So that's on the website, and I think you've laid out basically the contours of it. You're right, Jackie, that on its face, most of the time, there requires a significant amount of analysis to understand what terms and conditions are actually going to control any given dispute. And the sales team or purchasing team invariably thinks it's their terms and conditions that control because they were the one who sent it. And that can create some mismatches and expectations around what happens once there is a dispute or a question about the contract. With regard to your question about when to sign a contract versus when to engage in sort of PO and invoice relationships, there's a few things one is going to want to consider. The most obvious one is just, what's the nature of the contract? Is it ongoing? Is it a spot buy? Is it something that can be accomplished through a purchase order and invoice that requires a little bit less investment and resources into negotiating a supply agreement? That's the obvious one. Less obvious one might be if you have less negotiating power. If you're doing a deal with some of the giants out there, Intels or Microsofts or what have you, you're probably doing a deal on their commercial paper and not yours. And so if you know that you're not going to be able to get the concessions you need in that process, it can sometimes make sense to say, well, we're not going to engage in this long-term relationship. We're going to negotiate on this deal and only this deal, and then see if you can use that as kind of a starting point for the next buy or the next buy. And maybe once you've done 2 or 3, they haven't paid a lot of attention to it. You've built a little bit of precedent. Now you say, well, hey, let's firm this up into a supply agreement and let's use our previous dealings as the basis for that deal. So there can be times in which strategically, depending on your leverage, you might want to think of where you want to start.
Yeah, no, and that makes sense. I mean, if you have absolutely zero leverage, you're not going to get your terms and conditions that you want in the supply agreement. So at least you've got a shot at it if you're engaging the Battle of the Forums. But it is very easy to screw it up. And again, I sound like a broken record, but from my perspective, there's no predictability as to how it comes out if there is a dispute. So we can go on, Christina. Oh, so one practical point, this is less about what you might want to put in your contracts, but we thought it was worth pointing out, especially if you have a separate sales department and a separate purchase department, that it's really important to make sure your contracts match. You could be in the unhappy situation where you have a supply agreement where you've committed to a fixed price for a certain amount of time to one of your customers, only to discover that your supplier has raised prices and you no longer can get the margins or even perform profitably if you need to. So again, just a practical point, make sure that you are focusing on that and that they do match. I think we had one that you handled recently, Brandon, if I'm correct, where you had a customer with just that problem. I don't know if you were able to resolve it or if there were practical solutions, but what did you see there?
Yeah, so particularly amongst our manufacturing clients, we often have a primary supplier. Maybe they're providing a raw material, maybe they're providing a central component that goes into theirs. We had one recently where they were on a 5-year supply contract that allowed price escalation. I think it was once per year at a very set rate, but their supplier was not. They were on a 1-year and then allowed them, depending on who you ask, more frequent opportunities to increase their price. And they were, and our client was getting absolutely killed on margin because the supply side was going up and they had really very little ability to pass along that price increase. We did manage to get them through it, but it was uncomfortable, and their margins stayed very thin until they can get out from under that contract. And so we were able to avoid a negative margin situation, but it was a lot of challenges that had supplier and purchaser done a little bit more alignment on those issues. And this wasn't an issue of just negotiating party or leverage. One side of the industry did 5-year deals and the other side did 1-year deals, and that's just how they did things. And had they really brought those two groups together, into that they probably could have found somewhere in between.
Agreed, makes sense. Okay, so the next slide, Christina, if you would move us along. So just real quickly, and we won't belabor these, but a few thoughts about some of the pricing related provisions that we're seeing in agreements now. Hopefully this may be helpful to you, but these are kind of what's coming across our desks now. We're still seeing the fixed pricing where a supplier will give a fixed price for a widget and they'll attach the fixed pricing on their Exhibit A, or they'll put it on their website, but it is fixed at the time of signing the contract. Obviously, this is a good contract for the purchaser. They've got certainty, they know what they're doing. The supplier, not so much. Kind of on the flip side of that coin is the open pricing throughout the term, which is the price for the products will be whatever the price is at the time the seller accepts the buyer's purchase order. Again, flip side, great for the supplier, not so much for the purchaser. So a few ways where folks are trying to address the pricing risk. We see automatic increases where you will start with your fixed price on your exhibit, and then you will fix those prices by a certain percentage, either each calendar year or after some period of time, but it is a fixed percentage. And that begins to address some of the concern about pricing fluctuation, but it's not inordinately precise. It's just a fixed percentage. It's not necessarily tied to pricing pressures, the economy in general, or what have you. If you are doing that, you'll be negotiating what that percentage is, and that's still a bit of a crystal ball scenario. And then how often the prices will be increased, whether it is annually, whether there's a 2-year period where the prices will be fixed, and then you'll start with increases, but there's a lot of variations on that theme. And then moving on, there are the probably one, not that far on, one of the more common approaches is to do a price escalator that's tied to actual economic conditions. And sometimes that will be with a cap, sometimes it'll be without a cap. And you will have varying indices that you can choose from. A lot of folks will use the producer price indices and look for something in your industry that's helpful. We see it on the CPI and other indices. I have not used a raw material index, but that's certainly an option that some of my colleagues have used. And you will have that cap based on that particular index. The problem there is it is still, unless you've got the cap, still pretty unpredictable for the purchaser. And then finally, the supplier may try to pass their costs through. They'll have a clause that says, yeah, this is our price, but if our costs of production, our costs of goods sold go up, we're going to pass that along to you. Maybe with a premium, maybe not. The problem there, that's kind of twofold. If you're the purchaser, there's no real incentive to make sure that the supplier manages those costs and expenses. So oftentimes we'll also see a covenant to take reasonable actions and provide evidence of what the supplier has done to manage those costs. And if you are the supplier, you're going to have the whole issue of how do you prove what your costs were. If you're a sophisticated purchaser, you want a lot of proof. And then you're opening up your whole cost structure, your books, and it's not necessarily something that a supplier always wants to do. But there's a wide range of options. I'm kind of seeing all of them, probably more common than not, the price adjustment with a cap. But Christina and Brandon, I don't know what you guys are seeing. Anything in particular, or just depends on the fact pattern?
I've been seeing a lot more CPI chained price ones, and that itself, make sure you define which CPI because there's more than one. I had a dispute that involved that thankfully didn't go too far. The other one, I do see more of the raw material indexing, particularly in resins or stuff like that, and metals coming over. A word of caution on that. I've seen some really intelligent, elegant price adjustment mechanisms that have delays, and they on a 3-month, and they have averages, and they do this, and they seem great on paper. And then when the economy zigs, when you expect it to zag or it does something, they can end up really wonky and doing things that maybe the designers didn't walk all the way out. This probably goes without saying, but you really have to pressure test those formulas, and not with normal assumptions, but be a little weird, throw some weird stuff at it, and because things happen that where we had like the lumber short or the lumber spike that went through not too long after COVID. We had some weird ones that happened with that, where homeowners and home building contracts got really strange pricing. Where a house that was supposed to be $300,000 had $1 million price tag because of the way the formula worked, and you're going, well, now what? So just make sure those assumptions are thoroughly vetted if you're going to choose something that isn't just a percentage or something a little bit more straight line.
Yeah, no, that's helpful. And I've also heard horror stories about poorly drafted formulas too, which, is the litigation full employment guarantee.
That's right.
I don't think any of these are really necessarily perfect, unless your crystal ball is working really well, but that's kind of the panoply of what we're seeing right now. A few additional, we already had this one. Can we move that up one, Christina? Christina's driving our slides, so I apologize. I have to keep asking you to move them. A few other provisions to be aware of that are not necessarily pricing related, but they're kind of strategic, and they can kind of help you navigate that issue. One, sometimes, a purchaser may not be able to get a fixed price, but they may ask you to have a price match option where they can go out to a third-party vendor, come up with a good faith price, and give the vendor the opportunity to either match it, and then more typically, if they don't match it, the purchaser has the right to terminate the contract. It can be helpful. It's probably more helpful when your components and raw materials are readily available and you've got other sources for supply, but certainly something to think about. And then the next one doesn't look like a pricing issue at all, but it's what we talked about earlier, which is that we're seeing more termination for convenience clauses or other abilities to terminate a contract when pricing just gets too wonky. The problem there, of course, is that there's less certainty. If you really do need to lock into a price subject to predictable increases, it's harder to do that, but something to consider, and certainly something I'm seeing a lot more of than I ever did before. And finally, kind of the third of the price-related terms is that we will include the right to reject in some of our supply agreements, where the supplier will agree to supply product, but they reserve the right, they'll have a fixed price, and they reserve the right to reject those orders if the price is just too low and untenable. And that probably just gets you to the negotiating table rather than resolving anything, but it's a useful tool to have in your arsenal. And then finally, just a couple of provisions that are more kind of be aware items. If you do have an automatic renewal process, if the contract automatically extends for another couple of years, oftentimes it's sitting there in the digital file cabinet and no one pays attention to it. And before you know it, you're locked into another extended term without revisiting to look to see what the pricing looks like. So be sure to tickle those and make sure they're addressed. And then probably can't emphasize this enough. If you're a purchaser and you have particular needs in terms of your components, materials, it's good to have a transition period provision where after the termination of the contract, whether it's an early termination or even at term, although it's harder to justify at term, that there is a period where the supplier will agree to provide some goods for you to find a new provider and to transition the business. Next slide. Oh, yes, and one more related term, which is kind of what used to be the bid actor in the boilerplate world, has now taken on kind of a starring role in a lot of contracts, especially since COVID is really when we started seeing it, and people are trying to make their force majeure clause do some super heavy lifting. And this is one, I mean, our firm spent a lot of time dealing with this right at the beginning of COVID. And Brandon is one of our experts in this area. So Brandon, maybe you could kind of talk about how they're taking what used to be an act of God and are now using it to try to manage pricing pressures.
Yeah, no problem. So Jackie, like you said, prior to COVID, force majeure had a pretty well-established definition. It was acts of God, flood, civil unrest, government order, et cetera, that would stop a company from being able to perform their contract. And it didn't see a lot of activity or action in any contract negotiations for a while. The pandemic came along and everybody wanted to litigate whether that was a government order or an act of God and whatnot. And there was just enough authority floating around in the States for most people to say that it probably wasn't included in their force majeure clause, although it didn't stop us litigators from arguing it did. And there was all kinds of activity around that. What you saw coming out of COVID, of course, everybody put in a pandemic as one of their clauses in a force majeure clause. Although query what defines that, is it when the WHO says, when WHO says, or, Department of Health? There's some definitional issues there. But they started including other things in force majeure clauses, and such as, whenever an act of God, civil unrest, civil order, or other circumstances make it difficult or more costly to perform, or what is sort of language to that wishy-washy thing. And then would also have that a force majeure, traditionally, you could suspend your performance for as long as the force majeure condition existed, right? So if there's a flood, you can't produce widgets out of your factory. Once your factory is back up and running, you have to continue supplying the contract. What we saw was people putting in provisions that would say, well, if it made it more difficult or expensive to perform, we could raise our prices to the extent required from the force majeure event. And some people, having not really focusing on the term, accepted that. And we saw things like people paying extra labor rates for COVID employees because they needed to space them out or run more shifts, and them trying to pass along those expenses. So what was a very rare, seldom thought about provision became one where we saw sort of pricing, termination, all kinds of things being snuck in. The reason that's important, force majeure is 100% a creature of contract, right? There's no common law around it. It is whatever the parties agree to, and they tend to be strictly construed. So if it says, you're allowed to increase because labor got more important, you can do that. The flip side of that is, you want to be thinking about what is in the language of your force majeure clause. We had one, I don't know, 6 months, a year ago, where we had a conference that was scheduled at a hotel down in Atlanta. And the clause there for the hotel booking contract said that the performance would be excused. I think I have the language here somewhere. If circumstances were such that it was impossible or illegal to provide the services. Well, in Atlanta, there was a officer-involved shooting that led to some civil unrest. The police station was next door to the hotel. There was a flipped-over burning cop car next door. Riots in the streets. National Guard was called out and created a cordon that included 3 sides of the hotel. So we naturally called the hotel and said, thanks, we'd like to cancel our contract. Our attendees will not be coming because of this National Guard state of emergency. And they said, doors open, It's not impossible. It's not illegal. Nothing's preventing you from coming. You're welcome to come enjoy our lovely services. Sorry for the noise. So, and we had to tell our client, that they're probably of the better side of the legal argument. We have other ones, we can make it. And thankfully the hotel recognized they probably didn't want to be known for that kind of position, and they negotiated out some concessions that landed us there 6 months later. But you really want to be careful about the strict language of that, because courts are going to strictly construe that term, whether it's in your favor or it's not.
So that's really all I kind of wanted to highlight on the contracting part. So Christina, Brandon, I guess now it's time to talk about what happens when things go horribly wrong, notwithstanding Jackie's great drafting.
It's definitely notwithstanding though, for sure. So Brandon, I'm actually going to toss the mic to you now. We're going to discuss managing and resolving disputes, and I'll defer to you.
Yeah, thank you. So typically when I get involved, when litigator gets called, is because the dispute has already kind of come up. Somebody has tried to pass along a price increase and the client has decided they're not going to accept it, or alternatively, my client's getting killed on margin and they need a way to pass along a price increase and they don't see a clear path to doing it and they haven't found one yet. So we got to figure out what we're going to do in order to create some leverage where maybe the documents aren't readily apparent that leverage is there. I might spend just a minute, if I might, about some things that I kind of wish happened before I get called. So this is a little bit on Jackie's part, but the things that I've seen recur over and over again that may seem obvious, but would either avoid disputes or put somebody in a better position when one occurs. First one is if you're on a PO basis, invoice basis, and you're relying on your terms and conditions, you actually have to send them. And that seems really dumb. I can feel eyes rolling from here. But I would say 10 to 15% of cases I get involved in on POs, we cannot establish that the terms and conditions were sent. This happens for a variety of reasons. Sometimes they're on a separate piece of paper and it doesn't get sent. I've had ones where it was on a PDF invoice. Page 1 was the invoice. Page 2 is the terms and conditions. The sender was getting a bounce back from the other person's email. And so they cut off the terms and conditions and sent the invoice. That was the deal that ended up having a dispute. I've also had situations where there was reference to the terms and conditions on the website and we had a dead link. Or we've had ones where the link was there, but the version that was up there was updated after our dispute and nobody had proof of what the terms and conditions were before that dispute. So if you're going to rely on your terms and conditions, you need to send them. More importantly, for people like me, you need to have proof that you sent them. So whatever it is that your mechanism is for that, that you're gonna have to rely on your business team for that. You're gonna have to make sure the processes and procedures are in place to say that gets stored. Requote when quotes lapse. So you mentioned this earlier, quotes when they go out, if you have a time in which they must be accepted, and then let's say 2 weeks, 3 weeks, a month go by and somebody sends in a purchase order and they say, we're accepting that quote. That's fine. You can choose to keep your quotes open. You can choose to do business on those terms. But under a battle of the forms analysis, your quote may have lapsed and may no longer be operative. If that purchase order then becomes the offer that initiates the battle of the forms, and the other company has terms and conditions on theirs, and you think you're relying on your quote, you send the check, you send the invoice, it might be that your entire relationship is now governed by their extremely one-sided T's and C's because you let your quote lapse. So if you're going to use those sort of expiring quotes, requote or figure out how you're going to manage that process so that the battle of the forms puts you in a slightly better position to fight the battle of the forms. You talked about managing contract renewals. Just leave yourself plenty of time to do that. I can't tell you how often I get involved when they say, we're canceling this contract. Okay, great. What's the termination provision? 30 days, and it's day 28 or day 15. And I'm like, guys, we're not going to be able to do this under this termination provision. We're in for another year or 2 years or whatever it is, or we need to start figuring out, do we have any rights to claim breach or some other way of executing a termination provision? Price adjustments waiver. So you want to be careful if you have a pricing mechanism in your contract that you meticulously follow it. If you don't follow it, it happens all the time. People either don't execute the right formula, they forget on a quarter, whatever happens. If that happens over time, that can be considered a course of performance that modifies the contract. And so if you're going to give one-off dispensations from an adjustment, if you're going to say we're not going to execute it this month, but only this month, document. You need to make sure that that's in the record, that that's not sort of the first step in a course of performance that's going to establish the new terms of the contract going forward. All right, next slide, please. All right, so how does a pricing dispute typically start? So you'll get the dear customer letter. I'm sure everybody on this call has got one. Hey, you've been a great customer for many years. Effective 30 days from now, our prices are going up 20%. Thank you. You're a valued supplier. The funny thing about these is they're accepted like surprisingly often. So if you're out there in the supplier side, depending on whether or not you may have the leverage, sometimes it doesn't hurt to ask. I am shocked at how often these go through with not a lot of scrutiny, because at whoever's on the business side, it makes sense, or it's market or whatever, and they don't go and check to see what's our contract, what's our PO, do we have to accept this? If they think it's reasonable, they take it, and maybe you should pause and say, do we want to, and do we have to? You want to, excuse me, there's often an effective date is immediate or way too soon for you to do anything proactive with your other suppliers. So it's going to be a price that eats your margin, and you can't find another supplier that can supply that in the 30 days or 60 days. So it is one of those where you have to start thinking immediately, how am I going to push back on this price increase if we have the grounds to do so? And the one thing you want to be thinking about how to respond to a price increase is who, how, and when. The who can be important depending on your leverage. If you want that to be the business contact who receives it, if you want to leave room for management, inside counsel, outside counsel, those can all be decisions on how strongly do you feel about this, what do you want to send to the other side about whether you view this as business as usual or something where the supplier stepped out of bounds or transgressed in some way the relationship. Next slide, please. So the first one seems obvious. When you get these supplies, you need to know what contract governs. If it's a written countersigned agreement, great. You can go there and see, is this price increase permitted? Is this the time in which they can increase prices? Is it done the way that the contract permits you to? Somebody should take a look at that and just say, yes, this is permitted, or no, it's not, and here's why. If it's a PO or an invoice basis, you've got a different analysis there. You are going to have somebody determine what was the offer, what was the acceptance, what terms apply. I truly hope for those of you in the legal departments on the phone that your people are bringing you those issues as opposed to doing it themselves. I am often involved in disputes where management has gotten 3 steps out ahead and said, no, here's what our terms and conditions say about this. We win, you lose, and I'll see you in court, and here, talk to my lawyer. And when they talk to me, I have to go tell the business folks, that's probably not the case. And we've now led with our chin. And it's a little bit more difficult to craft an effective negotiation strategy when you've kind of already gotten out ahead of yourself and not left yourself room to escalate or room to, so just take a deep breath, analyze the situation before reacting. And that can include the legal analysis to make sure you're confident in your position before you advance it. And the initial response, what message do you want to send? Is it no? Is it no and what to your horse and you came in on? Or is it, hey, times are tough, inflation's tough, let's set a meeting, let's talk. And all of those can be used to calibrate based on basically how good of a supplier is it, how difficult is it going to be to find an alternative, but more importantly, where's your leverage in the contract, or where isn't it? Next slide, please. So what happens if somebody says no to the price increase? So typically what I see a whole lot of at that point is threats to cease performance, right? That means we're either going to cease shipping our product, or we're going to cease, or if you do so, we'll cease paying. If somebody, and that's often, if you're the supplier, that's often the only leverage you have, right? You can't just continue shipping and they're going to pay you at the lower amount. If you want to get those concessions as a supplier, you're going to need to threaten to disrupt something in order to do that, or business just continues as usual. Once there is a threat to cease shipping, you have a couple tools in your toolbox. The most common one we see and we use is what's called a demand for adequate assurances. It's a provision under the UCC that says if your counterparty gives you, reasonable, reason to believe that they will not perform their part of the contract, you can say, dear supplier, please confirm that you're going to provide the parts as required under the contract in 10 days, or we're going to treat this contract as being repudiated. And the recipient of a demand for adequate assurances has some choices. If you can either respond and say, yes, we're going to perform the contract, or you can provide something that doesn't provide assurances that you're going to perform. The result of that under the law is treated exactly the same as a breach of the contract. So once a party affirmatively repudiates their performance, you can sue them for breach right then and there, and the consequences of breach. So if you're the purchaser and your supplier says, we're not buying, and you have an alternative, you can go buy it from that alternative and turn and seek the delta in the price from the supplier who repudiated, even if that performance is not yet due, even if they've got 2 weeks before those parts hit your dock. So it's really a way of upping the pressure, but also putting on this legal framework for what happens next if somebody does persist with their threats to cease shipping. If you're on the receiving end of a demand for adequate assurances, you've got the same options. You can either provide them or not, but you want to be smart if you're going to not provide them in a way that doesn't trigger a repudiation if you can avoid it. So we often say things like, we're going to strictly honor the contract, meaning our interpretation of the contract in which your side loses. But you want to think about whenever you get a demand that's a serious moment. It has legal consequences for how you respond to it, and you make sure that you are shaping your message appropriately. The one thing to caution your group is a demand for adequate assurances doesn't have to say, this is a demand for adequate assurances under the such and such code. It can just be, hey, are you guys shipping on this date or not, as between the business folks. And when your business folks respond, yeah, over my dead body, unless you send me the increased pricing proposal, that's your repudiation. So the language is formal. The execution can be very simple, and people can get in hot water earlier in the process than sometimes one would think. Next slide, please. So, okay, they're not going to ship. They're not going to provide adequate assurances. And if you don't get parts on your dock by Monday morning, we're shutting the lines down. What do you do? So you can pay under protest. So that just means you're going to pay, but you're going to contest that their legal right to the money. What that does is that allows you to receive the goods, you continue your business, and you reserve the right to sue them over and not have your payment be treated as an accession or concession to the modified pricing. Also takes away all your leverage, right? Whatever calamity you were claiming was going to happen if you didn't get those goods is resolved. You've continued the business. You've got yourself a damages lawsuit right now. Sometimes that matters. Sometimes the actual change in the pricing isn't so much you're going to sue anyway, and so that's not a favorable choice, but it is one you can do. Likewise, you can continue, shipping under protest. So you didn't get your increased pricing, you think you're entitled to it, you continue shipping, and you're just accruing a damages claim that you may or may not pursue later. Be wary here. Substantial performance, substantial compliance. So maybe you view that the other side has only partially performed, and you're going to say, well, I'm not going to pay for that, and we're not going to continue our part. If a court later finds that they substantially complied, then you're the breaching party, not the other one. So I think a lot of people are very particular. They look for small breaches and say, well, that suspends our requirement to perform. Always be aware that substantial compliance is out there. It's an extraordinarily fact-specific issue. You may or may not know right then and there whether you're in that position. Just that's another one of take a deep breath before one declares breach and decides we're going to go for broke on a claim. I see we're nearing the end here. I'm going to speed through the rest of this real quick. always check to see what your venue is. Even if you've got a small monetary claim, if you've got venue in your backyard and your suppliers across the country, maybe you want to file declaratory judgment action, just having a court declare, hey, this is the price or this is the rights. Sometimes just making a supplier litigant can sober them up real quick and make them say, you know what, I don't want this fight. A declaratory measure, sorry, declaratory judgment is a softer step than suing somebody for breach. Still a lawsuit. They're still going to have to hire a lawyer. But it can be the shot across the bow that can get things moving. All right, they're not shipping. Line's going to stop on Monday morning, and if you don't supply your parts, you're going to shut down something that's even bigger, right? So maybe you can get an injunction. This is absolutely the time you want to be talking to your outside litigators. It's a very fact-specific inquiry, but you may be able to get an injunction forcing your supplier to send you the goods while you sort out the monetary issues. Just be careful if you are the person who's contemplating not shipping those goods. You can turn what is a small dispute, maybe this is a contract over 6 figures. If you are going to be shutting down, the Fords or GMs or the Intels of the world because you're not supplying your subcomponent and your contracts may entitle your customer to get consequential damages, you can turn a 6-figure dispute into a 7-figure a day dispute really fast. Ask me how I know. So the last one, always want to be careful about an uncollectible seller. If you've got somebody, supplier who's unable to supply at that price, and if you enforce, you're going to drive them, negative margin or drive them out of business. It may not be worth it. And sometimes all of the legal wrangling in the world doesn't matter if you're going to put somebody out of business or you're running them so thin on margin that they can't continue doing business. All you're doing is figuring out who's your next supplier, and if you give them a little bit of grace, often you can win friends, keep your supplier, and a little bit of relenting on this specific price increase. All right, last one. I'll sum up this one real quick and then leave a few minutes for questions if that works for you, Christina. The last one, obviously, whenever you're in a pricing dispute, you just got to be thinking at the margins for how do you expand the pie of possibilities, right? So, what's your alternative? Where else are you going to get these parts? If you can't get them from alternative, what else can you give and take? Maybe you can get better pricing, but you're going to guarantee increased quantities. Maybe you can change a non-exclusive agreement to an exclusive one. You can do a service or value add, something that you're supplying, adding an extra service component to that can make the deal work. You can do cost reduction strategies. So we've seen ones where we've done weight shaving and stuff like that that still allowed the parts to work, or lower cost replacements, substitutions, etc. All of which ways are saying before you kind of get into the full-on pricing dispute, I think a lot of people tend to get blinders on and say, yes, they can or can't push through this pricing increase. Once you're at loggerheads, it's time to kind of take the blinders off, sit back, collect, take a deep breath, and figure out what are kind of all of the options one can do to get over the hump, because your next option is talking to somebody like me, and your litigation is oftentimes more expensive than the dispute that's in place. And then a lot of times it's not. All right, that's my part. I think I went a little long. Sorry about everybody.
No, that was perfect. Thank you very much. The last 2 slides are just telling you a little bit about Quarles and Brady, because I know that we've been Paul Plevin here in San Diego for so many years. So the last 2 slides, feel free to peruse at your leisure. But I do not see that we received any questions in the chat, Alexa, but if anybody has any questions you'd like to put into the chat right now, we can address them. Otherwise, just feel free to email us at a later date. Okay. Still seeing none. I will say thank you so much for your attention and your time today, and turn this back over to Jonathan.
All right. Well, thank you again. And I did click on the link about the supply chain survival series, and it seems like there's a lot of good content there. So I'd encourage people to go check that out, and appreciate everyone's attention. And thanks again for the great presentation, and hope everyone has a good rest of your day.
Thank you, everybody. This is really enjoyed.
Thank you.
Thanks.